Good morning, Mr. Chapman.
Good morning, Your Honor.
You can proceed when you're ready.
Thank you. Before the court is Luke Van Valkenburg. Mr. Van Valkenburg is here today after failing to appear before this court on March 13th, 2024. For the record, that was a bench warrant hearing. Mr. Van Valkenburg had previously failed to appear before the referee. A bench warrant was issued, and then he paid the entire bond prior to having a bond review hearing, and then failed to appear for the hearing. Bond is currently set at $500. This is the second bench warrant. He reports no employment. The last payment made on this account was a $500 bond forfeiture on April 3rd of 2024. Further, the court recommends that a reasonable bond be set in this matter and it be scheduled for hearing on April 24th, 2024 at 8:45 a.m. before this court.
Okay. Mr. Van Valkenburg, you're before the court charged with civil contempt of court duty or failure to appear at a prior proceeding as a result of your failure to pay child support. Purpose of this hearing is to set a bond that would assure your attendance at the next hearing on April 24, 2024 at 8:45 a.m. You will get notice of that in writing. Are you able to post a bond, sir?
I do not have money, but my family may have some money.
Oh.
I don't really know what's going on. I don't know anything about court. Like, I really don't understand anything like this. I've been homeless for 4 years. I've been living on the streets in my vehicle. Like, I don't understand anything. I don't get any mail. I don't know. So,
okay. Well, what you need to do is you need to find a place where you can get mail at somebody's address, give that to the front of the court, and then they will give you hearing notices so that you don't miss those things because they'll continually send you those.
yes. It's being sent to my mother, but everything's like delayed a week or two. She's always going down to Alabama. She has a rental down there, so she rents it out and she has to fix it up. But yeah, everything's always delayed like a week or two to get into my hands, like my mail, anything like that that goes to her. But okay.
Well, what I'm going to do in this matter is say, how much was the bond last time, Mr. Chapman?
It was $500.
That's fine. Okay. Well, what the court's going to do is the court's going to continue the bond at $500. If you're able to post that, you'd be able to be released. Do you have any questions?
So if it gets paid, I'm gone.
If you pay the bond, you're able to get out. That's correct.
Okay, and then my next hearing would be the 24th. Where would that be? Here?
Yes, yes, it will. It'll be at the.
Okay.
What happens is that there's instructions will be by Zoom, and you can just basically appear like you're appearing today, except from the jail. You'll appear vis-a-vis Zoom. You can call in, or you can appear by computer. So you've got other options.
Okay.
Okay.
Now what happens if it doesn't get paid? How long do I have to stay here?
You'll stay there until the hearing on the 24th.
And what's the date? Sorry.
What's what?
Date? The date today?
The date is the 17th. So you'll stay there a week.
Thank you, Your Honor.
Okay. Thank you.
Will I be able to make calls after I get out of here? Because they put me in this like weird thing. They said I was suicidal when I was not suicidal.
Okay. Like, well, you have to talk to them down there. They control that.
Okay.
They don't have anything to do with the phone.
Okay.
Okay. Thank you. You're free to go. Have a good day.
Thank you. Have a wonderful day.
DP. Mr. Holcomb is here today after failing to appear before referee Coleman on November 17th, 2023. Bond is currently set at $1,001. This is the first bench warrant. He reports no employment. The last payment made on this account was in June of 2023. Front of the court recommends that a reasonable bond be set on this matter and it be scheduled for hearing on April 24th, 2024 at 8:00 a.m. before this court.
Mr. Holcomb, you're before the court charged with civil contempt of court due to your failure to appear at a prior proceeding as a result of your failure to pay child support. Purpose of this hearing is to set a bond that would assure your attendance at the next hearing on April 24, 2024 at 8:00 a.m.
Sorry.
Go ahead.
I was just gonna say, like, I will make sure I'm there. I'm sorry that, like,
I know you probably hear everything, but I don't ever remember getting any paperwork on that hearing.
Yeah, yeah,
I
we do
like
hear it all, Mr. Holcomb. You're right.
I know, and I'm not trying to just sell you a sob story or nothing. Like I love my son. I try to do everything I can for him.
Let me ask
I,
you, are you able to post a bond, sir?
um, I don't have no money. I mean, I hope my someone in my family might
Okay.
or your friend, but like,
Well, what I'm
yeah,
going to do, because it's your first bench warrant in this case, I'm going to reduce your bond the amount of $200. If you're able to post that, you'd be able to be released. Do you have any questions?
no, sir.
Okay, thank you. You're free to go. Have a good day.
Thank you, sir.
Yes, shall be the whole truth and nothing but the truth.
I do.
And
I
ma'am,
have
do you
a
have the script
couple
that we
of
would have provided to
benchmarks
you?
for the record.
Yes.
if I
Okay,
may.
you can go through that now. You don't have to disclose your address though.
Okay. My spouse and I were married on June 27th of 2019 in Calhoun County at Wilder Creek by a person duly authorized to perform marriages. I was a resident of the state of Michigan for at least 180 days of Calhoun County for at least 10 days prior to filing the complaint for divorce, now before the court. The allegations in the complaint were true when I filed it and are still true today. My spouse and I ceased living together as husband and wife on August 1st. There are 1 minor children born of this marriage, and I, Monique Bryant, am not pregnant. There has been a breakdown of the marriage relationship to the extent that the bonds of matrimony have been destroyed, and there remains no reasonable likelihood that the marriage can be preserved. If the court were not to grant a judgment of divorce, I would not resume a marital relationship with my spouse. The reason for the breakdown of the marriage is very personal. There are quite a bit of things, but I'm going to just say that we grew apart and it was time.
That's fine now. Well, we'll find that the testimony does establish a statutory basis. There has been showing there's been a breakdown of the marital relationship. The court will note that the court does have the proposed judgment and UCSO in this particular matter that are by consent. Ma'am, they're by consent, so the defendant signed those. Did you recognize the signature?
Yes.
Okay, and that is his signature that appears on those documents.
That is correct. I actually spoke with him this morning. He forgot that it was today, and he said to please just send a message that we agree upon everything. And
okay, thank you. Court will note the court does have further court approval as well. As a result, the court will enter the judgment and the UCSO. That will conclude your case. You are divorced.
I thank you, but I do have a question before it is concluded. There, he is keeping our home, but both of our names are on it. And I talked to the mortgage company, and they said they needed from you, whoever our judge was that granted the divorce, approval to take my name off of the mortgage.
Well, the only thing that the court would do, we don't prepare those. If the judgment of divorce provides that he is to receive the home, then they would be able to do that. Otherwise, you're going to have to, if you don't have that in the judgment, I don't have the judgment before me right now. If you don't have that, then you're going to have to do a quit claim deed where you would deed off the property and deed it over to him.
But with that, with the quick claim deed, I'm not sure that would resolve the debt. Also, my name being off of them.
It probably would not. So I don't know what the provision is in the judgment. Do you have your judgment in front of you?
No. I do. Let me get it.
Okay.
But that's what I'm confused about because I don't know. The mortgage company said that they would have to be because a quick claim deed would take my name off of the deed, but not the mortgage. They said that it was the only way that can happen is if the judge grants that, approves for my name to be off the mortgage and deed.
Well, I'm pulling up the judgment right now. So
I put it in there because also the reason why that I called the mortgage to find all this out was because he cannot refinance the home.
Oh,
because that's normally what would happen is he would just refinance, but he's not able because he wouldn't be able to afford the mortgage if he did that. I found where the judgment with the personal property and debt addendum, I just wrote in there that the defendant is awarded the following personal property, which is that. And in there, I did add a note stating this. Just that the defendant cannot afford to refinance the home.
Well, let me tell you what's going to happen. As I see, you would think that it would take care of this, but at least with the mortgage company, because you have a separate contract with them, they do not have to remove you from that obligation. In fact, it's going to, whatever you do after this, until such time as he refinances or pays it off, it's going to always show in your name. You know that.
Well, that's why I won't be able to purchase a new home. My debt to ratio right now, I'm renting a home for me and my children that is barely big enough for us. And I really would like to be able to purchase. And that's why it's so important for my name to be off the debt.
Well, the mortgagee would have to let you off that debt because what happens, that's a separate obligation. This court can't even order that you would be removed from that. I see it says here, it says that the defendant shall be responsible for the mortgage, insurance, taxes, liens, and other costs. But that at this point, because the mortgage company is not a party to this action, the court can't order that they would remove you from that debt.
Okay.
So if they do with the order that you have in the judgment, that's great. But I'm just cautioning you that they very well might not do that.
Yeah, well, they said to me, because when I talked to them, they said the only way to do it would be if the judge granted that. That's what they told me was my judge would have to award my name to be off of the debt.
Right. Well, again, what's going to happen is it's a matter if they'll take you off it, but I can't order it at this particular point, other than what you've put in your judgment.
Will you be able to approve it if that's what they need? If it's coming from you, if you approve that? Because that's why we agreed upon this. Like, I left everything for my peace of mind, and I let him have everything. That was the deal between us, that I would be able to get my name off of the debt and leave my home.
Again, it's up to the mortgage company. Because as I said, they're not a party, so I have no jurisdiction over them. And that's a separate contract action. And I can't, as a part of this action, I can't foreclose them from enforcing their contract rights. So if they're willing, based upon what you have in the real property addendum, if based upon that, they're willing to remove you from the mortgage, then you're able to do it. I will just caution you that they may very well not do that either.
So then what would our other option be? To have to sell?
The only other option would be to put in a proposed judgment, a time frame where he has to refinance it or sell it. One of those options.
Okay.
So I guess I'll ask you at this point, do you want the judgment entered as it is now written?
What will that affect if I say no?
Well, then you'll have to go back and prepare another judgment.
Okay.
And come up with something else. I don't want to enter this if you're going to take other action and prepare a separate judgment. And what you might want to do too is you might want to take the proposed judgment with your real property addendum and ask the mortgage company, does that suffice in removing you from the mortgage? Just because it says that he's responsible for that. They might say, no, you have to have a specific provision in the judgment saying that, that you're removed from that, but I can't imagine that they would agree to that.
So I don't know what, pretty much there's nothing that I can do besides make him refinance or make him sell the house.
Do you want some time to think about it? I can put this off for about, 14 days, let you think. And if you want to take some other action, then we'll just hold up on this. But I can't just leave it out indefinitely. So.
Okay. No, can you, is it allowed if I ask if I can have just a 3-minute, wait, a 3-minute wait so I can call him?
Well, what I'll do is I'll give you the 14 days. You can call.
I don't necessarily want the 14 days.
Okay. If you want to call us back in an hour or something, go ahead. That's fine. I'm not going to sign it right now. That way you have time to figure out what you want to do.
I just don't understand why the mortgage is telling me one thing and you're telling me another thing, and I don't know what. It's confusing because that's the only thing that is the holdup, is knowing what we have to do. I know for a fact that if I made him refinance it, he wouldn't be able to afford it.
I understand all that.
I don't want to do that.
I'm just telling you that notwithstanding what they have told you, legally, the court cannot order that they remove you from the mortgage.
What if they say, why did they say that then?
I have no idea. Unless you talk to somebody that doesn't know what they're talking about. But the fact is, we have this happen all the time where people they'll have something where they'll put it in a judgment saying that, that the plaintiff is to be removed from the mortgage, and that does not bind the mortgage company. And that issue has been litigated over and over. And so I know that they're not going to be bound by that provision. I'm just saying, if they will accept it, then fine, and they can remove you. But I'm just cautioning you to know, just because it says that doesn't mean you're going to be removed from the mortgage.
Okay. Are you willing to put that in there if that's what they want, so that way we can just be done with it?
Well, I'm not going to put it in there. You're going to have to change that addendum and get him to sign that and change it. And then I have no problem if the two of you agree to that. I'll put it in there, but I'm just cautioning you as well that they may not do it. And once you were to contact the mortgage company, they may say, well, we're not bound by that. So that's up to you.
I wish that he would have joined in this. Yeah, I talked to him and he said
well, regardless, it doesn't matter if he's here or not. The issue is with the mortgage company.
Right, I know, but if he was here and told you that he was okay with my name being off of it, would you put it in there? Because that's what they said that they needed when I talked to them prior to dealing for
again, you have a real property addendum that you're going to have to change to put in. So if you want to contact the mortgage company, find out specifically what they want in there, then you'll have to change it. Because all you're doing in the addendum you have is saying that he's responsible for those expenses. Doesn't say that you're being removed from it.
But if he's responsible for them, wouldn't that make it so I'm not responsible and that I would be able to be removed?
Because you're responsible by contract. So again, go to your mortgage company. If they're willing, if that provision's in there to remove you, you can add that into the addendum and we'll sign it because we don't have any issue with entering that. I was just cautioning you so you wouldn't think, oh, geez, I'm going to be off that when it's likely that that's not what's going to occur.
Okay.
Okay, we'll give you some time and I won't enter this. I'll give you 2 weeks, or if you can figure it out in an hour or 2 days or whatever it takes, you can just get a revised real property addendum to us, and then we will enter it. Okay. Okay. Right. Thank you.
Do I just call? Do I just get back on the Zoom in an hour or whatever?
No, you'll contact my office.
Okay. All right. Thank you.
Okay. Thank you.
All right, we will toss you.
Okay. Mr. Havard, in this matter, you're before the court charged with civil contempt of court due to your failure to pay child support and or related expenses. Upon a first conviction, you could be ordered to serve up to 45 days in jail. If it's a second or subsequent offense, up to 90 days in jail. Do you understand the charges, sir?
Yes, Your Honor.
Court has appointed Mr. Sackrider to represent you in this matter. Have you had sufficient time to speak to Mr. Sackrider in preparation for this case?
Yes, Your Honor.
Mr. Sackrider, you ready to proceed?
Yes, sir.
Okay. I guess you're frozen there. I do note Ms. Petrulla will have you sworn and go over it. I do have my notes from the prior hearing with Mr. Havard, but again, for purposes of this proceeding, I guess I'll have to have you repeat all of that. So, Ms. Petrulla, you can go ahead.
Thank you, Your Honor. It is the case of Corinne Hale versus Javon Havard, docket 2014-3305 DP. He is ordered to pay a $332 a month in child support, $10 a month in confinement expenses. $50 would be the guideline payment toward arrearages for a total of $395.50. That includes the service and processing fees. His last payment that he paid on his own was $50 on December 4th, 2023. He's had 4 show causes, 3 bench warrants, no findings of contempt. In the last 3 months, he should have paid a total of $997.50. He's paid nothing. That included a payment toward the arrearage, and his balance through this month is $879. He did file a motion to change his support, as you had told him he needed to do if he couldn't pay the ordered amount. And basically, that amount went up from $153 to $332 a month. He objected to that. He filed a motion to set it aside and had a hearing on Monday with Your Honor. And he was imputed. So the information, I know this is going to be sent back to the referee for income information, but he was imputed roughly at $15.50 an hour, working 40 hours a week. And that's how they came up with the $332. Okay. But nonetheless, he hasn't paid anything on his own since December 4th, when he paid $50, which was even well short of his obligation at that time of $153.
Okay.
And just for the record, Your Honor, we can't stop charges right now because Corinne Hale remains on Medicaid and food stamps. I don't think food stamps would affect it, but she is on Medicaid. And until she goes off, there's nothing we can do about the current support.
Okay. Mr. Sackrider, do you dispute or contest any of the statements made by Ms. Petrulla?
No, Your Honor.
Do you have any questions for Ms. Petrulla?
Yes. Was a tax garnishment taken for child support payments?
I don't believe that can be disclosed on the record.
Was he given credit for any of that payment?
Looks like there was a substantial payment that he did receive credit for.
Okay. So was that taken out? So that's how we were left. I mean, was that calculated? So that's how we're left with the $879?
Yes, Your Honor.
Okay. Go ahead, Mr. Secretary.
All right, no further questions.
Okay. Any proofs, Mr. Secretary?
Yes, I call Mr. Havard.
Okay, go ahead.
All right, Mr. Havard, you heard the testimony of Ms. Petrulio. Is there anything that you disagreed with?
There's nothing I disagree with, but like said before, we had the hearing on Monday. I had a hearing with the judge, Kirkham, and I told him my situation, and that's why we're going back to the motion hearing, because that was wrong information of the amount she's trying to say that I made. Like I said, I have a autistic child that I'm a full-time dad for. He's in ABA therapy from 8:30 to 12:30, and then I take him to school from 12:30 to 3:30. So it only gives me time to work a part-time job. I've been looking for jobs. I filled out for Flex, Amazon Flex. They said they're full. They'll put me on a waiting list. And any other job I've been filling out for Indeed, I don't get a call back because of my schedule with, I'm a full-time dad. I mean, the mom doesn't help. Like I said, my grandmother passed December 1st. So that's the reason why I've been having a hard time with the job situation. And that's the reason why I'm going back to the motion hearing to talk to the referee once again. And Corinne Hale is here, also the mother of my child, who we are here for. And we have been trying to opt out of friend of the court services, but Heather keeps on saying that I have to pay this and pay this. And she's making it hard for us to get out of this situation because we don't need the help anymore.
Okay. Well, sir, in this case, she has testified that that the mother is still receiving Medicaid for the child. You cannot opt out in front of the court if, in fact, there's public assistance involved.
We talked to her caseworker, and he's on her insurance, but it does take time for him to get off of Medicaid.
That's fine. I'm just telling you why it's still, why it's still being addressed by the front of the court. So
okay.
Your Honor, can I just?
Yeah.
This is a good time to say this. I did tell him that he would have to pay over $2,000 some odd for the confinement expense. That's another requirement, that confinement bill has to be paid before they can opt out as well. And I did give him that total balance.
Okay.
Thank you.
Okay. All right. So you filed a motion. You filed a motion with the court that was heard this Monday on the 15th.
Yes.
Okay. And were your taxes garnished this year?
Yes, my taxes were garnished to pay the last court hearing we just had like 2 months ago. That's the reason why we pushed it back, to see if my taxes were going to get garnished. I called in a couple weeks later, and those were taken, like 800 and some change. I don't know the exact amount, but 800 and some change was taken.
All right. You said you are caring for an autistic child. Is that a child from another relationship?
Yes, from a different relationship.
Okay, and do you have full custody of that child?
I have full custody of that child.
All right, how many children do you have with Miss Hale, Corinne Hale?
One.
And how often is your parenting time with that child?
About around 50% every weekend, and every time he gets a spring break or off day from school.
All right, so you're providing care for that child when you have them?
Correct, yes.
Okay. Are you currently employed?
No, I am not.
Are you filling out applications for employment?
Yes, I am. I filled out for Amazon Flex. That was the last employment I filled out for, and they reached back at me and said they would put me on the waiting list.
All right. How many applications per day would you say that you fill out?
I wouldn't say necessarily per day, but I would say like at least like 3 to 4 per week. I'm on Indeed.com filling out apps.
All right. How have you been supporting yourself?
Like I said, my child is autistic, so I get a SSI check from him, and I got Medicaid myself, and I receive food stamps, around like $500 in food stamps.
Okay. Anything else you would like to tell the court?
No, that's all.
All right. Nothing further, Your Honor.
Okay. Thank you. Sir, what's your education background?
It's high school. I had a high school diploma.
Okay. My understanding from the last hearing, you had testified that you had some CDL training. Is that correct?
Yes, I was doing CDL classes until my grandmother passed. Then it got hard for me to try to care for my son and go to school, so I had to stop the school. She was watching my child while I was doing the schooling until she passed.
You haven't paid since December 4th, 2023. Why is that?
Like I said, it's been hard for me being the full time. Like she abandoned him like 3 years ago, so I've had him in my care for 3 years. Like I still see my kids, so I still take care of them while I'm with them. So, and then I was just assuming that I file my taxes every year, that they would get the tax money every year upon, and that would clear the debt. That's why I'm like, why is the debt going up? And like, Corinne is here to agree with me that I do take care and help when I can for Logan, the child we're here for today.
Okay. Well, that's understandable, but you still have to pay on the support obligation. You can't wait until you get a tax refund once a year or something of that nature.
Yeah, I mean, I totally understand that, but it's just that, like, when I have him, I do provide. I buy clothes. I make sure he eats every day. I provide transportation. Like, I am providing for him at all times.
Understandable, and as a parent, you should be doing some of that, but that doesn't mean that you can ignore it the other times either.
Because it's like I'm basically paying twice, because I'm paying when he's with me. I'm also paying for, he's in basketball, he's in football. I'm providing for all those things, and then I have to pay the courts, because Corinne Hale would agree that we don't want to do the court system, but like you said, it's all these other things I got to go through to get out of that situation. So I'm not trying to ignore the fact that I have obligations to pay, but it's I'm not going to say it's pointless, but it kind of is. But I understand the Medicaid situation.
Okay. Well, and in this matter, it's just so you know that you do get credit for the time that you have the child with you. And the reason you get credit for that is so that you can pay for those expenses when the child's with you. So, contrary to what you said, you're not being double charged in this matter. You're being charged only for the days that the child is with the plaintiff in this matter.
But I still send money to the plaintiff if she asks for it.
And you shouldn't be doing that. You should be sending it through the front of the court, and then you'll get credit for that. Okay, anything else that you'd like me to be aware of, sir?
No, Your Honor.
Okay. Anything else, Mr. Sackrider?
I'd like to hear from Ms. Hale if she has anything to say.
Okay. Yes, Ms. Hale.
I'm not sure what's going on with my caseworker. I have spoken with her a couple times, but I would not like to say this, but everybody don't do their jobs correct, even though they're supposed to. So I'm going to try to get back in contact with her as well today. But I definitely agree. I would totally like to just dismiss everything. I help him too with his kid. So it's starting to become backwards. I'm helping him out, so it's like, it's harder for him than it is for me. I make a nice amount of money. I can afford to take care of my child, and he helps me when he can, and he helps out a lot. So it's just, I feel bad that we have to just continuously go through this, but I definitely just want to wrap everything up. Even with the rearages, I would not mind forgiving them. We already got daily lives and debts and stuff going on. So this should just add more fuel to the fire. And then, so I'm going to try to get in contact with my caseworker and see what's the holdup. I know everybody don't do their job though all the time. So
okay.
I've done my part on my end, and I've contacted her multiple times. So I'm I'll figure out what's that so we can wrap this up.
Okay. Ms. Petrulio, are the arrearages owed to the payee, or are they owed to the state?
Hold on, let me look. There's $207 that's owed in MS, which is the medical portion of the support. That's owed to the state. There is $560 through this month that is owed to the custodial parent. And then, of course, there's the confinement that would have to be paid. Yeah.
Okay. And ma'am, that $560, it sounds like you're willing to you forgive that and cancel that. Is that correct?
Yes.
Now you understand you're not required to do so, and that if you do it, it's voluntarily.
Yep, that's fine.
And you understand you can't come back in once you've waived that, and we've in essence removed that. You can't come back and say, "Oh, now I want that back."
Yeah. Yep. I'm fully aware.
Okay. Well, as part of this, the court will order that the arrearage of $560 owed to the payee is, in fact, canceled and eliminated in this particular matter as a result of Ms. Hale's agreement on the record to do so. So that leaves us with the medical and the confinement expenses as well. Mr. Havard, what's your plan for taking care of this?
To be totally honest, I mean, like you said, we have this motion hearing on Monday.
That has to do with your current support. It has nothing to do with the arrearages we're talking about today.
I'm going to try to pay what I can every month to get it knocked all the way down. I'm going to try my best, Your Honor.
Well, the history in this case is there's been a lot of adjournments, and I hate to do this, but I'm going to give you another adjournment for approximately 60 days, Mr. Havard, and I want to see what you're going to do in that 60 days. If you do nothing in that 60 days, then the court's prepared to have you go to jail. You understand?
Yes, yes,
so
sir.
You got to do something in that 60 days, or you're going to be incarcerated.
All right.
Okay. You're free to go. You'll get notice as to when that's going to be rescheduled, and we will talk to you back at that time.
Thank you, Your Honor. I'll adjourn that for the 19th happens to be a holiday, so we'll adjourn it to June 26th at 8 o'clock. And just for the record, there is $112 owed in service and processing fees as well.
Okay. So we'll adjourn it to June 26th at 8 o'clock a.m. then. Okay.
Thanks,
James, we're ready for your hearing.
Okay, thank you. Okay. Mr. James, in this matter, you're before the court charged with civil contempt of court due to your failure to pay child support and or related expenses. Upon a first conviction, you could be ordered to serve up to 45 days in jail. If it's a second or subsequent offense, up to 90 days in jail. You understand the charges?
Yes, sir.
I advise you, the court has appointed Mr. Sackrider to represent you in this matter. Have you had sufficient opportunity to speak to Mr. Sackrider in preparation for this hearing?
Yes, sir. I've talked to him.
Okay. Mr. Sackrider, you ready to proceed?
Yes, Your Honor.
Professor, you can proceed.
Thank you, Your Honor. We're here on 3 dockets involving Robert James versus Lisa Jones. There was a total monthly obligation of $53.50 that needs to be paid every month. The last payment that was paid was $1, and that was February 7th, 2023, that he had paid on his own. There's been 9 show causes, 3 bench warrants, 1 contempt finding, not including the hearing in February that we had. This was actually adjourned from February 7th, 2024 till today's date. The compliance, I monitored by 2 months at $53.50 a month. It equaled $107. $200 purge was supposed to be paid by April 17th. That total is $307 that should have been paid. The $200 purge was paid, leaving $177 left. The total arrears on this case is $608.11. The last sentencing on this case was June 21st, 2023. On February 7th, Mr. James was sentenced to 45 days in jail. He was told to pay as ordered starting February 2024, plus pay the $200 purge by today or serve 45 days in jail. He has only paid the $200 purge as of April 12th. On the 2014 docket, it's Vicki Huntley versus Robert James, an adjourned show cause from February 7th till today. His total monthly obligation is $469.50 a month. His last payment was $98.27 paid February 28th, 2024 by unemployment. There's been 7 show causes, 3 bench warrants, 1 contempt finding, not including the contempt in February. Monitored his compliance by 2 months at $469.50 a month. He should have paid $939. Then there was the $500 purge, which the total was $1,439 should have been paid. $601.30 was paid. His last sentence on this case was also June 21st, 2023. On February 7th, Mr. James was sentenced to 45 days in jail. He was told to pay as ordered starting February 2024, plus pay the $500 purge by April 17th or serve the 45 days in jail. Mr. James did pay the $500 payment April 12th. And then there's docket 2021 involving Michelle Pope versus Robert James. This is an adjourned show cause from February 7th, 2024. The total monthly obligation is $610.50. The last payment was $141.70 paid February 28th, 2024 by unemployment. There's been 2 show causes, 3 bench warrants, 1 contempt finding, not including the contempt found in February. I monitored his compliance by 2 months at $610.50. That equals $1,221. Plus there was a $500 purge. So the total amount he should have paid is $1,721. He had actually paid $641.70. The last sentence on this case was also June 21st, 2023. On February 7th, 2024, Mr. James was sentenced to 45 days in jail. He was told to pay his order starting February 2024, plus pay the $500 purge by April 17th, or serve 45 days in jail. Mr. James paid the $500 April 12th, 2024.
Okay. Mr. Sackrider, do you dispute or contest any of the statements made by Ms. Hester?
No, Your Honor.
Do you have any questions for Ms. Hester?
Ms. Hester, have you set up income withholding for Mr. James?
I believe an income withholding has been set up. I don't have that information yet, but I know that I had requested that.
All right, no further questions, Your Honor.
Okay. Any proofs, Mr. Sackrider?
Yeah, I'd call Mr. James.
Okay, go ahead.
All right, Mr. James, are you currently employed?
I am, sir. Hello?
Where are you employed?
Oh, sorry. I work at New Horizon Bakery in Fremont, Indiana.
And how much do you earn?
$22 an hour, sir.
And how many hours per week?
40.
How long have you been employed there?
A little over 2 weeks. I just got my first check, which I used to pay the $1,200.
All right. Did you notify FOC of your employment?
I did.
And have you set up income withholding?
When I talked to the lady, she said she would get the information over and get the paperwork sent out.
Okay. Did you have any taxes garnished for
I
child
did.
support?
It was a little over $1,400. I don't remember the exact amount, but I got a letter that stated that the income taxes were taken for back child support.
All right. Did you tell your enforcement officer that you were employed?
I haven't had a chance to talk to Jamie. When I talked to her earlier, it was short, and she said talk to the judge.
All right. Is there anything else you would like to tell the court?
I mean, just that I'm working. I'm paying as much as I can. I paid what I could. Like I said, when I got a job, I paid the purge. I mean, they've taken my income tax. I don't have any other money. I mean, other than the income withholding now that's being taken out when I talked to my HR lady.
All right. Thank you. I have no further questions.
Okay. So, Ms. Hester, I'm looking at this as we basically have about $1,850 approximately that's owed between the 3 cases. And so the amount, if his taxes were garnished and it's $1,400, then we're going to have a minimal amount of current, I guess, arrearage. Isn't that accurate?
Your Honor, no, the total arrears on each case, I'm sorry if I had skipped that. On the 1998 case, the total arrears is $608.11. On the 2014 case, it's $7,757. And the 2021 case is $13,621.78 that is owed.
Okay.
I have not seen any proof of any tax money coming in yet.
That's fine. I was just trying to figure out as far as the arrearages, and I didn't have the arrearages for the other 2 cases.
I'm sorry.
I had just the one I had $601, the other $641. So I don't know where those came from.
Oh, the 641 number came on the 2021 docket. He was supposed to pay $1,721 and he had paid $641.70.
Okay.
Yeah.
Okay.
So just the shortfall for the 3 cases that he should have paid in February and March is about $2,000.
Okay. I guess I'll ask Ms. Huntley, is there anything you would like to say?
No, sir.
Okay. And the other payee, I don't know what your name is because we have 3 cases.
My name is Michelle.
Michelle, what's the last name?
Pope.
Oh, okay. Is there anything you'd like to say?
There is. This is a pattern of Robert's going back his oldest case. His son is almost 30 years old, and he's in arrearages. It's a pattern. I think something different needs to take place. Otherwise, it's going to continue occurring like this. He has a son who's almost 30. He knows how this process works. And I don't believe the story about the taxes because he hasn't worked. That's why he's so behind on child support. Also, I just want it noted, this past Sunday, our daughter called her father, just wanted to talk to her dad because she was sad. And he told her he had to make it quick and short because he was on the Detroit River fishing. Robert has money. He has money. He can afford it. That costs money to go fish. You got to put you have to put gas in your boat. Also, the cost of all your jigs and everything like that. Something different needs to happen. That's why he's so far in arrearages with his son who's almost 30. Or it's gonna happen with my daughter and Vicky's. Family court, I thought, is supposed to have the best interest of the children at heart. And do what's best for them. This is not it. Robert is concerned about himself. He's concerned about himself. If he had $20 left to his name, he could have paid that towards his child support, but instead he went fishing. That costs money. I don't buy the taxes. I don't buy none of that. I don't buy it. His attorney, no disrespect to the attorney, he's new to, he goes off of what Robert tells him, just like the income withholding. His attorney asked him, did you tell your job about it? Well, no, I thought, come on, your son is almost 30. You know how this process goes. I was supposed to have an interview also at 11 o'clock today in Jackson for a job, which I had to postpone to this afternoon to attend this. I'm tired of doing this. We had a call in at 8 o'clock. I drive my daughter to school at 8 o'clock. Okay. So this is an anxious thing to go through. Nobody likes to do this. So my daughter has to experience her mom like on edge driving to school. And this takes away from me trying to provide for my child. Please, I just ask you to do something different. He's not a victim. You're not a victim.
Okay. Thank you. Well, what I'm going to do is I do obviously have some concerns as far as the taxes. And obviously that would take care of some of the arrears, but obviously not that much if you're only talking approximately 1,400. So what I'm going to do is I'm going to adjourn the matter to July 3rd, 2024. And I'm going to want to see what you do in the interim, Mr. James. And I will tell you, you're going to have to do something more substantial than what you've done. You're going to have to start paying regularly and putting something additional towards the arrearage in that meantime, or you could find yourself in jail on the 3rd. So we'll come back on July 3rd, 2024 and see what you've done in the interim.
Okay. Thank you, sir.
Okay.
Yep.
Thank you. And Ms. Huntley and Ms. Pope, thank you for coming. I know it's a burden, but we're trying to do the best we can to collect this. So
can I add something just real quickly?
Okay, go ahead.
He has open court cases, and I don't know if it's district or circuit court right now at Calhoun County for failure to pay his city income taxes. So
okay. I believe that's none of our business here.
Yeah, ma'am, that has nothing to do with this hearing.
Good try.
So what happens is we're only interested in what we're able to collect here. And if he has other cases, he has to deal with those as well.
I was mentioning that because he said he was using taxes to pay out.
Hey, Mr. James, when somebody else is talking, don't interject.
Sorry, sir.
Go ahead.
Oh, no, I was just saying, I just was mentioning that just because, his thing is he filed taxes and they're going to, that's all. I just wanted to point that out that he doesn't file taxes, but
okay. Well, we will see, because when we come back on the July 3rd date, that will definitely be enough time for that to be processed. And if he hasn't done it, he's just simply saying that, then he'll have to explain that. Okay.
Absolutely.
Thank you all, and you're free to go. Have a good day.
Yes.
Okay?
Thank you.
Mr. Kelly, in this matter, you're before the court charged with civil contempt of court. as a result of your failure to pay child support and or related expenses. If you're found in violation and contempt, you could serve up to 45 days in jail. If it's a second or subsequent offense, up to 90 days in jail. You understand the charges?
Yes, Your Honor.
Court has appointed Mr. Sackrider to represent you. Have you had sufficient opportunity to speak to Mr. Sackrider in preparation for this hearing?
Yes, Your Honor.
And Mr. Sackrider, are you ready to proceed?
Yes, Your Honor.
Okay. Ms. Hester, you can go ahead.
Thank you, Your Honor. This is docket number 2012, Jade Haggerty versus Brandon Kelly. We're here at an adjourned hearing. It was adjourned from February 7th, 2024. The total obligation, monthly obligation that needs to be paid is $1,035.50. The last voluntary payment was February 6, 2024, in an amount of $1,100. There's been 3 show causes, 0 bench warrants, 3 contempt findings. I monitor compliance by the last 2 months at $1,035 a month. That equaled $2,070. There was a purge amount to be paid of $1,000. That total equals $3,070. The total amount paid was $2,000 with a shortfall of $1,070. The total arrears on this docket is $7,117.20. He was sentenced, his last sentencing was June 21st, 2023. For 21 days, $500 purge, and then he was sentenced again February 8th. February 7th. Mr. Kelly was sentenced to 45 days in jail. He was told to pay as ordered starting February 2024, plus pay the $1,000 purge by today, April 17th, or serve the 45 days in jail. On Monday, April 15th, 2024, Mr. Kelly paid the $1,000 purge and $1,000 payment. He also reported to me this morning that he could pay the shortfall of $1,070 today. In front of the court does not have any objection to that if you don't.
Okay. So what do we need to do, Ms. Hester, if he makes that lump sum payment today?
If he makes that lump sum payment in front of the court, he has no objection to this being dismissed, and I'd continue to monitor.
Okay. Mr. Kelly, did you hear what she said?
Yes, Your Honor.
So if you make the payment of $1,071 today, then the case will be dismissed.
Yes, Your Honor. I will do that today.
Okay. We'll take you to it, because if you don't, she'll have you back in a few weeks, and then we'll proceed and finish the hearing, okay?
Yes, Your Honor.
Okay. You're free to go. Have a good day.
You as well. Thank you.
So, Your Honor.
I gave you an easy one, Mr. Sackrider.
Yes, thank you, Ms. Hester.
So, Your Honor, I can just put that the next hearing's before you then?
Yes, that's fine.
Okay. Thank you so much. Have a good one.
Before the court charges civil contempt of court due to your failure to pay child support and or related expenses. Upon a first conviction, you can be ordered to serve up to 45 days in jail. If it's a second or subsequent offense, you can spend up to 90 days in jail. You understand the charges?
Yes, I do.
And in this matter, the court has appointed Mr. Sackrider to represent you. Have you had sufficient opportunity to speak to Mr. Sackrider in preparation for this matter?
Yes, I have.
Thank you. Mr. Sackrider, are you ready to proceed?
Yes, Your Honor.
Ms. Brown, you can proceed.
Thank you, Your Honor. Ms. Campbell is before the court on a bench warrant hearing on docket 2019. She has a monthly obligation of $412.50. Her last payment was April 27th of 2023, and that was for $94.83 through income withholding. She failed to appear on December 11th of 23 for a adjourned show cause hearing before referee Coleman. This is her first bench warrant. She did have one prior contempt finding back by the referee on August 4th of 23. And at that time, she was given a 45-day suspended sentence by referee Bradfield. And then she failed to appear at the adjourned hearing in December before Coleman. For 7 months of compliance, Ms. Campbell should have paid $2,887.50. She's paid nothing. Her total arrears are $9,408.70. Ms. Campbell booked into the Calhoun County Jail on April 7th. Okay. The court would also like the court to be aware that Ms. Campbell has received at least 3 LEAP referrals. She did participate in LEAP one time. She's been referred multiple times since that one successful completion. And she has not been successful with the last 3 referrals.
The last three or the last two? You said there were three referrals and
Well,
she did comply.
She's been non-compliant with the last three referrals.
Okay.
Yes, that's it. Thank you.
Mr. Sackrider, do you dispute or contest any of the statements made by Ms. Brown?
No, Your Honor.
You have any questions for Ms. Brown?
No, I don't, Your Honor.
Okay. Any proofs, Mr. Sackrider?
Yes, I'd call my client.
Okay. Go ahead.
With that,
Okay. Ms. Campbell, you heard that testimony. Was there anything that you disagreed with?
no, sir. I would like to be compliant with the LEAP program when I get back out, if that would be an option.
Wait, ma'am, we just lost him for a moment.
Go
Okay.
ahead. Go ahead.
All right, Ms. Campbell, when did you book into jail?
April 7th.
All right, do you have an expected release?
Not yet. I just got 93 days.
Is that on a separate criminal matter?
Yes, sir.
Okay. Is that in Calhoun County?
Yes, sir.
All right. When was the last time you were employed?
Oh, last year,
Approximately when?
July of last year, or May, June, May, somewhere around there.
And where were you employed?
I was employed with PCS. What is it called? Perfection Commercial Services.
All right. So since July, how have you been supporting yourself?
I really have not. I've been homeless. It's been very difficult for me. That's why I wasn't able to comply with the LEAP program. But when I get out of here, I'd like to hit the ground running. And if I can, get another chance to be referred to the LEAP program, I very well will follow through with everything I need to do.
All right. Do you struggle with substance abuse or alcohol?
Substance abuse, yeah.
Have you ever done services through Summit Point?
I was starting to, yeah, not recently, but I will. I'm down for whatever. Anything that you think that would improve my life and me being able to pay, I'm willing to do.
All right. What's your highest level of education completed?
GED.
All right. Do you have any felonies on your record?
Yeah, one felony.
All right. What's your plan to pay this child support obligation in the future?
As soon as I get out of here, I'm going to go to Tennessee where my kids and my father are located and get a job and start paying immediately.
All right. Anything else you want to tell the court?
That's it.
All right. Thank you.
Okay.
Thank you.
Ms. Campbell, in this matter, you said, well, your plan is to go to Tennessee and to get a job. Why haven't you done that before?
Well, I was on mental health treatment court, Your Honor, and it held me here in the state.
Okay.
But I miss my kids, I miss my family, so I can't wait to get this all taken care of and get down there. It'll help with my substance abuse too.
Okay. Why, you had worked, you said, up until sometime in July. Why haven't you worked after that date?
Well, just being homeless has made it difficult for me to obtain or keep employment.
Since July, have you sought out employment? Have you put in applications, went to interviews?
Oh, yeah. Yeah, I've put in multiple applications through, online.
How many applications would you say you did in the since?
Oh, I don't know. I bet you 1,000, 500.
Okay.
But I just wasn't being serious about my life from being homeless and I guess being in a cloud of drugs. And I apologize for that. And I'm excited for my life to start over.
When you put in those applications, why do you think you didn't get any offers?
Oh, every time I turned around, my phone number was changing, or I couldn't get access to those emails I had. It's just always been something, Your Honor. something, a streak of bad luck. But I love my children and my dad, and I just want to do what's right.
Well, that's fine. That's admirable, but we are here to address why you're not paying, and you're about $9,500 in arrears. So
yeah, that's scary.
It is. Did you say, maybe I have this mixed up with it? You do have a GED, so.
Yeah.
Well, there's obviously a substantial issue in the workforce with needing employees. So I guess I'm befuddled a little bit as why you couldn't get employment.
Yeah. I guess I just probably didn't follow through good enough, Your Honor. Like I should have. I should have been more pushy and stuff. And I knew I had warrants for other matters, and I was just really afraid, and I was homeless. So.
Okay. Anything else that you'd like me to be aware of, ma'am?
No, sir.
Okay. Anything else, Mr. Sackrider?
Nothing further.
Okay. Well, in this case, of course, for the testimony that as stated, Ms. Campbell has a sizable arrearage of approximately $9,400 that I don't understand with the amount that's owed. She hasn't sought out or sought to have that reviewed. She's ordered to pay $412.50 per month. And obviously, based upon the little that she said, that she may qualify if she took some action to have the support reviewed. She did have a prior 25-day suspended sentence in this matter, that she'd been referred to the LEAP program 4 times. She only participated once. She, I think is what she says, is probably consistent with everything that she's done as to the LEAP, as she's saying that she simply has not followed through on things. And that does appear to be the case, that her intent is to go to Tennessee to get a job, but she hasn't done that previously. She had all sorts of issues put in, as she claims, probably up to 500 applications, but her phone was changed. She didn't have access to the app to see if anybody had attempted to contact her. So the court doesn't find that that's a good faith attempt at compliance. Court notes that she clearly is aware of what her support obligation is. She's failed or refused to comply, and as a result, she is in contempt of court. Anything before sentencing, Mr. Sackred?
Yes, Your Honor. My client testified that she's struggling with substance abuse. She's willing to get help. We would ask that any jail sentence run concurrently with her other outstanding jail sentence for criminal matters. We would ask the court to set a purge amount in the amount of $100, Your Honor. Thank you.
Okay. Ms. Brown, you have any problem with a concurrent sentence or?
No, Your Honor. No problem at all. Okay.
What the court's going to do, Ms. Campbell, I'm going to sentence you up to 45 days in jail with credit for 10 days served. I'm going to have that run concurrent with your current sentence, so that doesn't put any additional days on you. But again, I'll tell you what happens if you come back into court. The court could go up to 90 days. So the fact that you're getting the 45 days does have some consequences. The court will set a purge amount in this matter of $500, and that will be the sentence. You're free to go. Have a good day. Thank you.
Thank you.
Mr. Karras, in this matter, you're before the court charged with civil contempt of court due to your failure to pay child support and or related expenses. Upon a first conviction, you could be ordered to serve up to 45 days in jail. If it's a second or subsequent offense, up to 90 days in jail. You understand the charges?
Yes, I do.
The court has appointed Mr. Sackrider to represent you. Have you had sufficient opportunity to speak to Mr. Sackrider in preparation for this hearing?
Yes, I have.
Mr. Sackrider, are you ready to proceed?
Yes, I am, Your
Ms.
Honor.
Brown, you can proceed.
Thank you, Your Honor. Mr. Karras is before the court on 2 matters, docket 2012 and docket 2019. On the 2019 case, the parties are married, and the total arrears owed on that case is $347.97. The 2012 case, Mr. Karras has a monthly obligation of $267.50. His last payment was October 6th of 2021. That was $68.04 through an income withholding with unemployment. He's had 4 prior contempt findings. For 2 months of compliance, Mr. Karras should have paid $535. He's paid nothing. Total arrears on the 2012 case is $18,000. $765.50. Friend of the court would like the court to be aware that the hearing today is actually a compliance hearing. He was before your honor on February 24th. At that time, you adjourned the matters to monitor Mr. Karras's Social Security claim.
Okay, hold on. Oh, there it is. I get my notes from that other hearing. Okay,
yeah.
Go ahead.
Since that hearing, friend of the court has not been able to confirm that Mr. Karras has even applied for benefits. He has also failed to submit medical documentation to our office repeatedly. So here we are today. That's all I have.
Mr. Sackrider, do you dispute or contest any of the statements made by Ms. Brown?
No, Your Honor.
Okay. Any questions for Ms. Brown?
No, Your Honor.
Any proofs?
Yes, I call Mr. Karras.
Okay.
All right, Mr. Karras, you heard the testimony of Ms. Brown. Is there anything that you disagree with?
I got paperwork in the mail from the court saying that I only owed a total of $770 on Caitlin. And it was like $441 at the time on my case with Elijah.
Okay. And who are those papers from?
The courts there in Battle Creek.
Okay. And what do you take those papers to mean?
That's all I owe. It says in total I owed what was the total of those two amounts, and that was it. It didn't say nothing about 18,000 or nothing else. That's all it said I owed.
Okay. Ms. Brown testified that this was adjourned for you to provide medical records. Did you hear that testimony?
Yes, I did.
Did you provide medical records to Ms. Brown?
I didn't even have a doctor at the time. I just now got insurance on the 1st of the month, so I could go and get scheduled with a doctor. They're scheduling out way out months and months now, and I've got one set up for the 1st of the month.
Okay, what is your disability or injury?
I have shoulder injury, neck injury, and back injury.
All right, are those preventing you from working?
Half the time I can't even walk. My left leg goes numb, it gives out on me, and then I'm for a day or two I can't feel nothing below the waist.
All right, when was the last time you were employed?
Right before the car accident.
When was that?
2002. I mean, no, 2022. Sorry. Duh. Sorry.
All right. You filed for disability?
Yes, I have.
When?
Like 3 weeks ago, I think it is.
All right. Do you have a lawyer helping you with that?
Not at the time. I don't.
All right. How have you been supporting yourself?
I haven't been. I haven't been able to do anything. I'm stuck. No way to get around, no way to do nothing right now.
You have an income?
No, I do not.
Have you been applying for jobs?
If I can't walk, how am I supposed to do a job?
All right. Where have you been living?
With a friend of mine.
Okay. Are you a veteran?
Yes.
Have you applied for any VA benefits?
Yes, I have. And they, for some reason up here in Michigan, they cannot find my file. But if I go down to Virginia and get my file, they find it.
All right. So you are eligible for benefits?
Last I knew I was.
All right. Did you post a bond at this matter?
Yes, I posted a $400 bond for the Janet Shepard case. And then I posted a $100 bond for the Monica Karras case.
All right. It was your testimony that your daughter Caitlin does not live in the state of Michigan. Is that correct?
Yes, she doesn't even live in the state of Michigan.
So she does not. Does she stay with Janet Shepard?
No, she does not. She lives with her brother on a military base down there.
Okay. Are you willing to file a motion to have that support modified?
Yes.
All right. Anything else you would like to tell the court?
I'm trying to do everything you guys want me to. I'm sorry it takes so long for the medical out for them to get up here where I'm at, but I am trying to follow with what you guys want me to do to show you the proofs and everything.
All right, thank you. No further questions.
Okay. Mr. Karras, from the last hearing, I have my notes, and when you were asked at that time as to why you were disabled, you said you had an injury to your left thigh. You did not mention your shoulder, neck, or back at that time. Why is that?
It's my whole lower section, my hip, all across my lower back. It's the whole lower section, my hips and everything.
Did you simply forget to mention your shoulder, neck, and back the last time?
Yeah, actually, I did, Your Honor.
How have you supported yourself if you haven't worked since 2022?
I had a lawsuit. That's where I thought I thought all my child support. I got the paperwork from you guys saying that I only owed so much because it got taken care of from my lawsuit. That's what I thought. That's what I was told. Is anything from child support would come out before I got my money.
Okay, it might tell you that it would come out, but it didn't say that they collected anything at this point. Has your lawsuit been resolved?
Not if you guys haven't got your portion, because I didn't even receive nowhere near the amount they said I was going to. And I tried to call this law firm, and now they won't answer the phone at all.
Ms. Brown, you didn't mention any lump sum from any action. I would assume you haven't gotten anything?
Nothing, Your Honor. We haven't even sent out a lien to an attorney. I've never been provided any of that information about a lawsuit. We haven't received a lump sum payment. There hasn't been a lien established. It's been we're approaching 3 years that I've been requesting medical documentation from Mr. Karras, and he's never submitted it. So there's a pattern of him stating that he has injuries, but there's never been any verification of any of that to our office.
Mr. Karras, in the 3 years, why haven't you provided that medical?
I did send in some documents of some work of my doctor signing me off work saying I was not able to work. And the court, and then I got told that those weren't good enough. And they were directly from my doctor.
Okay. Anything else that you'd like me to be aware of, sir?
Not that I know of. Not that I can think of.
What's your education background, sir?
I have my GED and then military training.
Okay.
I also have vocational school, an electrician's vocational school.
Your Honor, may I?
Yeah.
Yeah, I overlooked this initially. So there is a cost recovery request from the sheriff in the amount of $74.38 associated with the bench warrant back in February when Mr. Karras was before the court. So we'd like to address that today.
Okay. Anything else, Mr. Sackrider?
No, nothing further.
Okay. Court will make the following finding in this case. Mr. Karras has appeared. He did appear previously before the court back in February. The court adjourned the matter to today's date to give him an opportunity to do a number of things that he could do. He stated that he was pursuing some disability. We haven't received any information about that. We haven't received any information concerning his medical situation. He claims he was injured back in an accident back in March of 2022, so it's now 2 years post. We haven't received any information about that. He said he submitted some medical information, but it was not sufficient in this particular case. That's not unusual where doctors will submit something, but it doesn't delineate what their disability is or the time off or what their limitations are. And he was informed of that, but he hasn't followed up and gotten anything. In fact, he said up until just recently, he didn't even have a doctor. And he didn't have insurance that he did. Now he set up something for the first of the month. He also noted that back in February, when the court asked him as to his disability, it was with his left thigh. Now he's stating that his injuries are to his shoulder, neck, and back. And that he does have GED. He has also electrician vocational training in this matter, but he simply hasn't worked since 2022. And he's well aware of the support obligation in this matter. Court will find that he's not made a good faith attempt at compliance. He's failed or refused to comply, and therefore he's in contempt of court. Anything before sentencing, Mr. Sackrider?
Your Honor, you heard testimony from my client. He is a veteran. He's been struggling essentially with homelessness. He's staying at a friend's. My client, I do believe, is eligible for benefits. However, he doesn't have the means or the wherewithal to obtain them. We would ask that if the court does impose a jail sentence, the court say purge him out in the amount of $100, Your Honor. Thank you.
Okay, thank you. Court does note that he had 4 prior contempts findings on the one case, and the other he had 0 prior contempt findings. The court is first going to order that you reimburse the sheriff transportation costs of $74.38. The court would forfeit the bonds previously posted in this matter. The court is going to sentence Mr. Karras to 45 days in jail with credit for no days served. The court would order that he report to the sheriff no later than 4:00 p.m. on April 26, 2024. Sir, if you don't report at that time, you could be sentenced to a greater period of time and serve, in fact, more than the 45 days. The court would allow him to purge himself of contempt by paying the sum of $500. So if you're able to pay the $500 before the April 26th date, then you would not have to serve the time in jail. Do you have any questions, sir?
No.
Okay.
Your Honor, I do have a question. So the $500 purge is on the 2012 case. On the case where he is married to the respondent and the arrears are just over $300.
I'm putting zero purge on that.
Okay, just to be sure. Thank you.
Yep. Okay. Thank you. You're free to go. Have a good day. Is this Gina's case?
Yes.
Okay.
Yes.
Mr. Stone, in this matter, you're before the court charged with civil contempt of court due to your failure to pay child support and or related expenses. Upon a first conviction, you could be ordered to serve up to 45 days in jail. If it's a second or subsequent offense, up to 90 days in jail. You understand the charges?
Yes, sir, I understand.
I will advise you that you have a right to an attorney. The court would appoint an attorney to represent you should you desire an attorney. I understand that you wish to proceed without an attorney. Is that correct?
Yes, sir, I wish to proceed without a attorney and stop wasting court's time.
Okay. Are you doing so freely and voluntarily?
Yes, sir, I am.
Has anyone threatened you, coerced you, used any undue influence, pressure, or promises to get you to appear without an attorney?
No, sir, they haven't.
Okay. Court will find that Mr. Stone does freely and voluntarily waive his right to an attorney. I'm going to have you, Mr. Stone, and Ms. Mouton.
Your Honor, in the matter of Gamble versus Stone, docket 2007, respondent Renaud Stone is here for a bench warrant hearing because he failed to appear for a show cause hearing on February 14th, 2024 before Your Honor. Mr. Stone is currently ordered to pay $245 per month for current support, $122.50 on the arrears for a total monthly obligation of $371 to include $3.50 for service and processing fees. The last payment received on this docket was on April 18th, 2022 in the amount of $72.69, and that came through income withholding. This is Mr. Stone's 5th show cause, 6th bench warrant, and he's had 2 previous findings of contempt. I measured his compliance over 6 months. Mr. Stone should have paid $2,226. He paid nothing, so that is his shortfall. Total arrears on this docket are $8,724.75 through March 31st, 2024. Mr. Stone did book into Calhoun County Jail on April 9th, 2024, so he would have credit for 8 days. And he had a prior 45-day jail sentence on May 14th, 2013.
Okay. Mr. Stone, do you dispute or contest any of the statements made by Ms. Mouton?
No, sir, I don't.
Do you have any questions for Ms. Mouton?
No, sir, I don't.
Okay. What would you like to tell me, sir?
Like I said, I had an interview set up for this right before I got locked up, and I was really working on trying to get everything in order because, like I said, COVID hit and everything kind of fell for me. So I finally got everything going in the order that it should be going to try to get a job and get everything paid and taken care of because I got a granddaughter now, so
okay.
I'm trying to
Well, your last employment, the last time you paid was back in 2022. When was the last time you were employed?
That's when I was employed at the place before COVID had kind of hit, and it kind of stopped us from working because of COVID and stuff. So I ain't been employed since.
How have you supported yourself if you haven't been working since 2022?
I actually have been doing a little lawn service, trying to start a little business up, but that kind of fell short for me because I got COVID twice in a matter of time, and my sister had got stage 4 cancer at the time, so I started trying to help her, but I've pretty much leaned off my parents.
So your family's supporting you?
Yes, sir.
What have you done since back in 2022 to acquire employment?
Well, I have been, like I said, I have been doing a little lawn service and everything, but like I said, I had the COVID twice in a matter of time. And
okay, well, I understand that, but we're talking 2 years, and when you have COVID, you're basically out of basically out of commission for a couple of weeks is what it is. So in the 2 years, you got maybe 1 month total that you were not able to work and be around people. So what have you done the other 23 months?
But actually, the year kind of just began, and like I said, I dropped the ball. I honestly dropped the ball at the time because of what had happened with me losing my job previous. And like I say, I'm kind of trying to pick the ball back up and getting everything protected.
So I take it in the last 2 years, you haven't done anything to acquire employment.
Yes, sir, Your Honor.
Your Honor.
Yes.
Mr. Stone was actively participating in the LEAP program, but he wasn't meeting their deadlines, so he was dismissed from that program.
Why is that, sir, that you weren't meeting the deadlines for the LEAP program?
I actually had lost contact with the information because I failed to pay my phone bill and everything, and transportation-wise, and not having a driver's license to get around town, sir.
Okay. What's your education background, sir?
I actually got just the GED from it. I was finished 10th grade.
Okay. Well, I'll inform you just so you know that, again, you have a right to seek a modification of your support obligation should you desire to do so. You can do that by filing a motion with the Circuit Court Clerk's office, and you can get the forms from them to do it. Anything else you'd like to tell me, sir?
No, sir.
Okay. Well, in this matter, the court's heard the testimony in this case that Mr. Stone does have an obligation of $371 per month, that his last payment was back in April of 2022, that he claims that he's not worked since that time other than he was doing some lawn care. But during that, he claims also to have had COVID on 2 occasions, that he has been supported by family. And as he stated, he simply has dropped the ball, that he hasn't done anything since 2022 to acquire employment other than the lawn service. Further, he was dropped from the LEAP program because he didn't comply with that and to, again, keep up with what he needed to do in that program. He said he lost the information. And the court will find that he has failed to exercise good faith compliance. He's failed to refuse to comply, and therefore he is in contempt of court. Anything before sentencing, sir?
No, sir.
Okay. Well, the court notes he'd had a prior 45-day jail sentence. I'm not going to increase that. What I'm going to do is I'm going to impose, sir, 45-day jail sentence with credit for 8 days served. The court would allow you to purge yourself of contempt by paying the sum of $500. Do you have any questions, sir?
No, sir.
Okay. That will be the order of the court. You're free to go. Have a good day. Mr. Shepard, in this matter, you're before the court charged with civil contempt of court due to your failure to pay child support and or related expenses. Upon a first conviction, you could be ordered to serve up to 45 days in jail. If it's a second or subsequent offense, up to 90 days in jail. You understand the charges?
Yeah.
You're frozen for a minute. Okay. Sir, the court has appointed Mr. Sackrider to represent you. Have you had sufficient opportunity to speak to Mr. Sackrider in preparation for this proceeding?
Yes.
Okay, Mr. Sackrider, are you ready to proceed?
Yes, Your Honor.
Ms. Mouton, you can proceed.
Your Honor, in the matter of Coleman versus Shuford, docket 2000, Dante Shuford is before the court for a bench warrant hearing because he failed to appear for an adjourned show cause hearing on March 13th, 2024 before Your Honor. Mr. Shuford is currently ordered to pay $400 a month for current support, $200 towards arrears for a total monthly obligation of $603.50 to include service and processing fees. Last payment received on this docket was on February 26, 2024, in the amount of $11.89, and that is the only payment that has been received on this docket. Mr. Shuford did post a bond in the amount of $200 on April 5th, 2024, to be released from Calhoun County Jail. This is his first show cause, first bench warrant, and he's had no previous findings of contempt. I measure compliance over the last 6 months. Mr. Shuford should have paid $2,421. He paid $11.89, leaving him a shortfall of $2,409.11. Total arrears on this docket are $13,091.61 through March 31st, 2024. Friend of the court did try to measure Mr. Shuford's time in Calhoun County Jail, but did want to let the court know that he was incarcerated on March 16th, but the friend of the court bench warrant did not go out until March 18th. He was released April 5th, so I'm not sure how you want me to calculate his days.
You say that when did the bench warrant go out?
It went into lien on the 18th of March.
Okay. Okay, thank you.
You're welcome.
Mr. Sackrider, do you dispute or contest any of the statements made by Ms. Mouton?
No, Your Honor.
Do you have any questions for Ms. Mouton?
Yeah, what was the source of the payment in February? Where did that come from?
It just says that he made the payment, so I'm not sure. It didn't say employment.
All right. I have no other questions.
Okay. Any proofs, Mr. Sackrider?
Yeah, so call Mr. Shuford.
Okay, go ahead.
All right, Mr. Shuford, can you hear me?
Yes, I can.
You heard the testimony of Ms. Mouton. Was there anything that you disagreed with?
I never made a payment. This is my first time going through it, and it's like my daughter. Like I got her right now. I always have my daughter, but it's like I was just incarcerated. I don't got nothing. Like she had that whole part right when I had got locked up. I had reached out to him and let him know I was locked up, but it's kind of been hard. You know what I'm saying? I've been looking for. I can show my Indeed account. I put in like plentiful applications. I can send printouts in or whatever, because you can look all them things up on Indeed, all the applications you file. I've been trying to get employment since I've been released from just being incarcerated. And then like that 200, a friend helped me out and paid that for me. I didn't even have that. That's because I was locked up when I got locked up in March. I couldn't even afford bond. That's why I was sitting in there until my court date. I had to sit in there until it got dismissed at court. And then the child support warrant came up, and a friend helped me pay the little to $200.
All right. How many children do you have with Brianna Coleman?
You said, is there anything I want to say on behalf of her?
No. How many children do you have with Brianna Coleman?
I have one child, her right here.
All right. What is your parenting time?
I have her, like, she started preschool, so I really don't have her throughout the week like that as much, but I used to have her for all the time. Her and her mom used to live at my mom's house. I just, like, if y'all address y'all have for me was in Minnesota, I had to leave my mom's house so my daughter and her mom can have somewhere to lay their head, because they had nowhere to go. So I was trying to go see if I could do better out of state and everything. Like, I'm still in a messed up position trying to get it together. But me getting locked up really was dragging me down, holding me back for real.
When did you live in Minnesota?
I was down there New Year's. I went down there last November, came back the end of this January.
All right. So from January to when you were incarcerated on March 15th, were you employed?
No, I wasn't.
All right. You said you were filling out applications for jobs, correct?
Yes. And I can print out and show it's on Indeed.
All right. How many applications per day would you say you were filling out?
I mean, I feel out like it won't even like altogether since I've been out. I can say I filled out at least like a good 400 apps. So I would say like probably like 13 or 14 a day. Cause some of them be having they'll send something back to your email and how you have to do skill tests and like map. It'll be a map test, a skill test, and stuff like that, and send it in and wait on a response and everything. But I got the emails that when a lot of places that I filled out apps at, they move forward in their hiring process and then choose me because they also send that email to you when they don't hire you or turn down your app.
All right, what's your highest level of education completed?
Oh, I got my GED.
All right, what are the reasons they're saying they're not hiring you, if any?
I got several felonies that I'm in a process. I have a court date and on June 24th to get 3 of my felonies set aside. It's called set aside convictions. You know what I'm saying? I gotta send this my fingerprints to the Michigan State Police Office. I do gotta send that in. But I'm in the process of getting multiple of my felonies removed right now. I'm waiting on a court date. It's June 24th for sure. I already have a court date.
All right. When was the last time you were employed?
The last time I was employed was probably the end of last year. So I was employed 3 weeks. I was a part of the solar panel when that Marshall WAC when they was in Marshall with that project.
Okay. And why didn't you make a payment then?
Because I worked 3 weeks. I had to wait 2 weeks to get my money, and I thought this is how I thought it worked. I thought when the federal and state take money out your check, it goes towards your child support and stuff. And they was taking money out like for the 2 checks I got. But you got to work 2 weeks before you get 1 check in any job, and then the next week you get paid again. So I was only there for 2 checks, and then they ended. They got to laying people off because the job was basically done. But I did make a payment, but it was like I don't know. Like I'm a full time. My kids always with me. I was spending. I can show. I ain't got no receipts right now, but I can show where I take care of my everything they got is for me. Like, and I got another child that's not even on child support that I take care of. But her mama even testified all the things I do for my daughter and her living at my mom's house and everything. This my daughter right here. Her mom is Brianna Coleman, and she vouch for everything I say and everything. And I just can't afford. I really want a reevaluation because my situation is not matching up to paying 600 rearages and 400 a month child support. I was just incarcerated. That was my last known address where y'all reached out to me at. I've been trying to gain employment. I can't afford that right now. I really feel like I need a whole new reevaluation of like my situation because I don't know where the numbers come from that they got added up that they want me to pay back like that.
All right, what's your plan to pay child support in the future?
Definitely trying to get a job. And if I might, you know what I'm saying, I might. It's getting warm. I'll get out here with a rake and a lawnmower because I do own them things too. Well, I own a lawnmower, but a rake ain't want to be hard to get. I do outside jobs and stuff too, though. I know how to do all types of stuff that I'm not even certified to do, though. That'd be my only downfall. Right. Where you going? Come here, bud.
All right. How have you been supporting yourself?
Man, we've been house to house and my mom and them moving. So it's like, I'm trying to get everything together. I get food stamps, so I be, paying my stay with them type stuff. Where I be going at the time. Sometimes, like it'll be for a couple of days or whatever. And I don't even think but I ain't really got money to give. Some of these family different houses I just be bouncing around too. But I'm in emotion. Once I get a job, all that'll be straight though. I just feel like I'm being pressed about what they want me to pay. It's like they telling me if I don't pay this, I'm gonna go to jail. Like it's like I can't. I was just in jail. How do y'all expect me to have all this money right now? Is what I'm saying. And I ain't even been out of jail 2 work weeks. I've only been out of jail like 12 days.
All right. Anything else you want to tell the court?
That I want to say, ask the judge, like, can they revise? I gotta need a reevaluation because I can't afford the money that they're asking me for.
All right, thank you. I have no further questions.
I will let you know, Mr. Schubert, that you have a right at any time to seek a modification of your support. you simply have to file a motion with the court in the clerk's office. They have forms there that you can fill out and file and get a review of that support obligation.
Okay.
You said you were working odd jobs. How much were you making in a given month doing your odd jobs?
It don't be like every day. It just be like I got people that I used to, cause I also was doing like lockouts in cars. Like,
okay, well that's why I asked as far as an average in a month. How much would you say you made in a month on average?
In a month, it's like I'm not certified to do what I do, so I charge lower prices, which make them want to try to call me though. When I do get service though, it only be a couple hundred a month though, but it'd be basically like pennies though, a couple, but it don't come all at one time. It'd be like spread it out. Like every time I get somebody a call and it's be like, oh, can you make it over here and help and change this tire and put this spare on for me? You know what I'm saying, go over there and charge them $35, $40. But I only have like a call and maybe two, like if I'm lucky. Like when the snow was going on, I used to have a lot of more service because cars was getting stuck and not unlocking, or they was doing what they was doing or not starting. So, once since it's been warming up, it's really slowed up. It's like it got slow.
Okay. Why when it was busy, why were you not making any payments then?
I knew I was on child support, but I'm new to this. I don't know nothing about this, Your Honor. I never got told I had to pay anything or nothing. Last time I heard about got any notices from child support was years ago when I stayed in Minnesota, when I told her my address and she gave it to her child support officer or whoever, and then they sent me court papers up here, and that was years ago. Okay. Like I never heard nothing else about it. This is my first time ever going through any of this.
Okay. Anything else you'd like me to be aware of, sir?
I am trying my hand when Indeed. I be also putting in applications locally too, but it like that really be slow though. But I'm waiting on several temp agencies to get back with me. They sent my name over to plenty of jobs, so I'm just waiting on them to get back with me. And then I just had a court case that I had to pop up in the computer that said closed because one temp agency couldn't even send my name over to a job because they don't take pending cases. But the case got dismissed almost a week and a half ago, and it still was popping up as open on the internet or whatever the thing that jobs use to search and see if you got any pending cases.
Okay. Well, in this matter, the court makes the following finding that Mr. Schufert had testified in this case that there was a period of time when he was incarcerated, when he couldn't be working, obviously, that he had put in applications through Indeed. He had put in a number of those. He claims he thought about 13 on average per day, that he does have a GED. He also has a criminal record that is prohibiting him or impeding his work. He last worked in the end of 2023, where he worked for 3 weeks. However, during that time, when he had 2 checks, as he stated, he did not apply any of that money towards his support obligation. His last and only payment was from 2/26/2024 for under $12. That notwithstanding that, he said he does work odd jobs. He made an average of $200 per month, that it was much more substantial when he was doing snow work and all of that, but it slowed down in the spring. So the court will find that he did have the ability previously, because of his odd jobs, to make payments. He failed or refused to make any payments in this matter. As a result, he is in contempt of court. Anything before sentencing, Mr. Sackrider?
Yes, Your Honor. My client testified that he put in 400 or 500 applications on Indeed. He is looking for work. He's struggling with being in and out of jail and some homelessness. We would ask that the court give him more time to comply with his child support obligation. If the court does put in place a jail sentence, we would ask for a $100 purge amount, Your Honor. Thank you.
Okay, thank you. Court will first note and will forfeit the bond previously posted by Mr. Schufert in this matter. The court will, Mr. Schufert, I could sentence you up to 45 days in jail. I'm not going to sentence you to that much. What I'm going to do is I'm going to sentence you to 35 days in jail with credit for 24 days served. Court will allow you to purge yourself of contempt by paying the sum of $400, and the court will order that you report to the Sheriff's Department on April 26, 2024, no later than 4:00 p.m. If you do not appear to the Sheriff's Department by that date, when you come back in, you could be sentenced to more time in this particular matter. You understand that?
Yes.
Do you have any questions?
No, I don't.
Okay, you're free to go and either pay the purge amount of $400 before the April 26th date, or show up at the jail before 4:00. So.
And how many days do I got to serve?
You have 11 additional days to serve.
Okay.
I never
Okay.
get Mr. Malone
You're free to go.
back,
Thank you.
and I asked the custodial parent to try to communicate, and she says that he's not responding to the text messages.
Okay, so he's absconded in front of the court, would request that a bench warrant be issued and that bond be set pursuant to statute.
Court would enter a bench warrant for Mr. Malone as a result of his leaving again the waiting room and not reappearing. Court would set his bond in the amount of 25% of the outstanding arrears, or $500, whichever is greater.
Thank you, Your Honor. That's all I have today.
Mr. Sackrider, is that all you have?
Yes, it is.
Okay.
What was the case number for Jason Malone?
That one is 2004. You should have just received it this morning.
And who is the petitioner?
Jennifer Cummins.
All right, thank you.
You're welcome.
Thank you for your service, Mr. Sackrider. You have a wonderful day. You're before the court charged with civil contempt of court due to your failure to pay child support and or related expenses. Upon a first conviction, you could be ordered to serve up to 45 days in jail. If it's a second or subsequent offense, up to 90 days in jail. You understand the charges?
Yeah.
Court will advise you have a right to an attorney. The court would appoint an attorney to represent you should you desire an attorney. It's my understanding you wish to proceed without an attorney. Is that correct?
Yeah.
And are you doing so freely and voluntarily, sir?
Yeah.
Has anyone threatened you, coerced you, used any undue influence, pressure, or promises to get you to appear without an attorney?
No.
Okay. The court will find that Mr. Davis does freely and voluntarily waive his right to an attorney. Ms. Dolph, you can proceed.
Thank you, Your Honor. We're here today on two matters of docket number 2013 and docket number 2021, both involving Mr. Wade Davis. We're here today for a bench warrant hearing on both of those dockets after he failed to appear at a compliance hearing that was referred from the referee to Your Honor on February 21st, 2024. On docket number 23, Mr. Davis's total monthly obligation is $95.50. This comes from $67 for current support. He is ordered to pay $25 per month on arrears and $3.50 for processing fees. The last payment received on this docket was $23.09 on February 12th. For enforcement history on this case, this is his 7th show cause. He's had 9 bench warrants and 1 contempt finding. Measuring compliance for the last 6 months at a rate of $95.50 means Mr. Davis should have paid $573. He has only paid $123.09, making his total shortfall $449.91 for the last 6 months. Total arrears on this docket through the end of March are at $3,991.91. On docket number 2021, his total monthly obligation is $338. This comes from $192 for current support, the guideline amount for arrears repayment at $111.50, and monthly confinement fee of $31. His last payment on this docket was $76.91 on February 12th, 2024. The enforcement history on this docket is he's had 3 show causes, 3 bench warrants, and 1 previous contempt finding. Measuring compliance for the last 6 months at the rate of $338.50 means he should have paid $2,031. He has only paid $176.91, making the shortfall for the last 6 months $1,854.09. Total arrears on this docket through the end of March 2024 is $11,175.40. In front of the court would like Your Honor to be aware that the 1 previous contempt finding was from June of 2023 when he was sentenced to 21 days in Calhoun County Jail.
Okay, thank you. Mr. Davis, do you dispute or contest any of the statements made by Ms. Tull?
That was a lot. I can't I'm sorry, it was a lot to even try to comprehend. But I will say I thought I was in contempt of court for failure to appear. As far as like payments, I pay what I can afford.
Okay, well, we'll get to that. My first question is, are you disputing or contesting anything she said?
I guess this would be the part I would need a lawyer for.
Well, she offered you a lawyer. You didn't want it at that point. You want a lawyer now?
To understand what was just said, I mean, no, I don't know. I don't want to contest or to dispute what was said. What was just basically said was there's a lot of money that's owed, not owed. Payments wasn't made, or how much should have been paid.
Well, what I'm going to do, Mr. Davis, if you want to speak to an attorney, I'm of course going to adjourn the matter to allow you to speak to the attorney. The court will adjourn the matter to May 15, 2024 at 8:45 a.m. You'll then have an opportunity to speak to an attorney. Okay?
Sir, look, I really just want to get to the bottom of what was my warrant about. I was told I missed court. I've proved I was here at court for another hearing. I even came down and tried to.
Well, we're dealing now, sir, with the fact that you haven't paid child support. So
I've been making the payments I can afford to pay. I mean,
well, I understand, but you haven't been paying what you're ordered to pay. So that's the issue. Do you want an attorney or not?
Yes, yeah,
okay.
Yeah.
We'll adjourn the matter to May 15, 2024 at 8:45 a.m. to allow you to have an attorney.
Yeah.
Okay, you're free to go today, sir.
All right.
Mr. Lip, in this matter, you're before the court charged with civil contempt of court due to your failure to pay child support and or related expenses. Upon a first conviction, you could be ordered to serve up to 20 or 45 days in jail. If it's a second or subsequent offense, up to 90 days in jail. You understand that? Sir, can you hear us? Sir, are you able to hear us? Mr. Lip, are you able to hear us?
Kind of. I'm having some super troubles with my phone.
Okay, well, tell me when you're able to hear us, and because we want to make sure that you can hear everything we're saying. Are you able to hear us?
Yep, I can hear you now.
Okay, well, stay there. Don't keep moving around, and as long as you can got a place you could hear.
Yep.
You're before the court charged with civil contempt of court due to your failure to pay child support and or related expenses. Upon a first conviction, you could be ordered to serve up to 45 days in jail. If it's a second or subsequent offense, up to 90 days in jail. You understand the charges?
I mean, you can't say that I failed to pay because I have paid.
Okay, well, we'll get into all that. I'm just saying that's the basis.
Okay.
Do you understand that?
I mean, I guess.
Okay. Court would advise you have a right to an attorney. I would appoint an attorney to represent you should you desire an attorney. It's my understanding you wish to proceed without an attorney. Is that correct?
I mean, I'm here because I'm having trouble paying my child support, so I can't really afford an attorney.
Okay. Are you, again, are you waiving the attorney? Are you doing that freely and voluntarily?
Yeah, there's no way I can pay for one.
Okay. Has anyone threatened you, coerced you, used any undue influence, pressure, or promises to get you to appear without an attorney?
No.
Court will find that Mr. Lip does freely and voluntarily waive his right to an attorney. Ms. Toth, you can proceed.
Thank you, Your Honor. We're here on two matters today. It's docket number 2014, docket number 2016, 338. Both of them involving Mr. Philip Lip. We're here today on an adjourned bench warrant hearing after I had adjourned this matter from January 2024 to allow him to be in compliance with the order of the court. On docket number 2014, he is currently ordered to pay $53.50 a month. This is currently a zero support order, but friend of the court does want Your Honor to be aware that a 21-day proposed order did go out about a week and a half ago. So support is in the process of potentially being reinstated. But for right now, it's $53.50. The date and amount of his last payment was $300 on January 3rd, 2024, and that was a bench warrant resolution payment. This is his fifth show cause. He's had 3 bench warrants and no prior findings of contempt. Measuring compliance for the last 6 months at the rate of $53.50 means he should have paid $321. Not including that bench warrant payment that he made, he has only paid $300, or excuse me, he is short $321 because he has paid nothing. I'm sorry. The total arrears on this case are at $5,472.77 through the end of March. On docket number 2016, his monthly obligation is $546.50. That's coming from $493 for current support, $50 a month towards arrears, and $3.50 for service and processing fees. Last payment received on this docket was $150 on April 1st, 2024. This is his fourth show cause. He's had 3 bench warrants and no findings of contempt. Measuring compliance for the last 6 months means he should have paid $3,279. He has only paid $450, making his shortfall $3,129. Arrears through the end of March 2024 on this docket are at $14,827.32. Friend of the court does want your honor to be aware that when I've spoken to him, he is a truck driver. He stated that work isn't always consistent. So payments on both of these cases are very sporadic. When he does make payments, they are not meeting the total obligation. When I last spoke to him in January, I did advise him of the various ways to go about filing a motion and things if he could not afford current support. Nothing has been done in that time, and he is not making the monthly payments as ordered. So that's why we're here.
Okay. Mr. Left, do you dispute or contest any of the statements made by Ms. Stahl?
Well, I just made a payment on the 28th of March.
Okay. Well,
two payments.
Okay, then those probably have not been processed and wouldn't appear. Do you know on the March 28th date, what did you pay?
I paid $150, so it would have been $75 on each, and yeah, and then I just got this load. This is the first time I've had work since probably the last 2 months, so I'm sitting here right now waiting to get reloaded. When I get back, I'll have more to be able to do, but yeah, I can only do what I can do when I can do it.
Okay. Well, let me know why. Obviously, you see that there's a need for truck drivers out there. Why have you not had regular employment?
I would really like to know that too. If there was a way to get my boss to keep me working, it would be a whole different story. But when I'm out here and I'm gone away from home for, a month on end, and I've only got one load under the books, it doesn't really work out so good. He's got me sitting more than anything. So that's why I'm seeking new employers, because this isn't working. I've been here for the last year, and it's been a mess.
Okay. Well, I just note that when I travel the highways, I see on almost every truck where they're advertising for truck drivers. So,
well, I'd really like for them to get hit for false advertising, because all the ones that say that they're paying $2,000 plus a week and this, that, and you get these bonuses. Yeah, no, it's not. That's not the case.
But we do know that there's a substantial need for truck drivers at this point. I just can't understand why you can't get consistent jobs.
Yeah, I'm in the same exact position, because I'm like, you know what? I've been at this. I got my license in 2016, hoping that this was going to get me out of this hole that
Ms. Talpa told you back in January, she informed you about seeking a support review. Why haven't you done anything with that?
Well, I haven't been at home enough to really actually get that done, but now that I've started to slowly get stuff back on track, I didn't really have a good place where I was able to get everything going. But now that I've actually gotten stuff established and I'm slowly getting back on track here, I've got the house rented now and the rent's paid for. So that's been all right for right now. It's like a month to month thing. So if I'm, short on that too, I don't have a place to stay. So I think I've got that dealt with and figured out. I've got Kendra a room and everything set up. So for when I go to actually push these motions and stuff, because she's been staying with my mom for like the last 6 years. So regardless of what her mom wants to try to say or do or whatever, I know where my daughter's at and how it's been going on. So, and that was something me and my mom worked out long before I got back on the road.
Okay.
But yeah, going forward, I'm going to be pushing the motions to try, because I would like to file for custody of Kendra, seeing how she's having such a hard time with her mom and at her mom's house. That'll be my end goal.
Okay. So what I'm going to do, I've got the information that we have. I'm going to adjourn the matter to June 19, 2024 at 8:45 a.m. That'll give us additional time to see what you do in the next couple months. So we'll see you back at that time. And we will have the attorney on that date. So if you did want representation, you could have the attorney as well. But I want to see what you're going to do in the next few months. If you don't do anything, you probably better plan on going to jail. But we'll give you that opportunity to do something. Okay.
All righty. I appreciate it.
Okay. We'll see you back then, and hopefully you can find a new employer and one that can work you on a full-time basis.
Oh yeah, I've been looking. I'm tired of being over the road too, so I'd like to find something local.
Okay. Okay, we'll see you back on that day. Good afternoon to both of you. I guess as I was reviewing this, I note that there was a genetic DNA test completed, but I don't think we have that. Ms. Harley, did you file that, or what's happened with it?
I asked them if they needed it, and they told me just to give it to you if you needed it.
Okay, well, we would like to have it so we can have it in the file. Do you, Mr. Magnuson, have you seen that at all?
No, I have not, Your Honor.
Okay. Okay, what we will do is we will require that you file that. Ma'am, in this matter, you filed the complaint seeking to determine that the child is in fact not issue of this marriage and is a child born out of wedlock. When you filed your petition on March 15, 2024, were all those statements true, and do they remain true?
Correct.
Okay. You have, as you stated, you did complete the genetic DNA testing in this matter. Does it show, was that testing of Mr. Harley or testing of Mr. Wellington?
It was tested of Mr. Harley. I can show you if you'd like.
Oh.
But I do have it. I do have it on hand, and I can bring it down before I go to work today.
That'd be great, because what happens, I won't sign an order until such time as we get the DNA test results.
Yep, I can do that before I go into work today.
And on that, it'll have a probability of paternity. What does the report state as it relates to probability of paternity?
It says 0%.
And what entity completed that DNA testing?
The DDC.
And in this matter, if you would, during the time of conception of the child, were you engaged in sexual relations with the defendant?
No.
Were you engaged in sexual relations with the alleged father, Jeffrey Allen Wellington, Jr.?
Yes.
And is there any dispute or doubt in your mind that Mr. Wellington is, in fact, the biological father?
No.
Okay. Mr. Magnuson, do you have any questions of the plaintiff?
Just briefly, Your Honor, ma'am, you are willing to cooperate in the event that we need to establish paternity for Mr. Wellington?
Yes.
And I'm going from memory here, but he has maintained some type of relationship with the child?
Yes.
Okay.
He has been in Joseph's life since day one.
Okay.
And remains till this day.
And again, not to be repetitive, but there's no doubt in your mind that Mr. Harley is not the father of this child?
No.
Thank you. I have nothing further.
Okay. Mr. Wellington, you've heard the testimony of Ms. Harley in this matter. Do you believe that testimony is accurate?
Yes.
And at the time of the conception in fact, were you engaged in sexual relations with the plaintiff?
Yes.
And do you believe that, in fact, the child, your biological child?
Yes.
Do you have any doubt of that?
No.
And since the child was born, have you, in fact, maintained a parent-child relationship with the child?
Yes.
You understand by acknowledging paternity in this matter that you subject yourself to various financial obligations to maintain and support the child?
Yes.
And are you willing to do that?
Yes.
Mr. Magnuson, do you have any questions for Mr. Wellington?
No, Your Honor.
Thank you. Well, I think based upon the testimony, and I don't know that you don't need any closing argument, do you, Mr. Magnuson?
No, Your Honor. I think clear and convincing evidence has been presented to the court that Mr. Harley is not the father, and then upon presentation of the genetic testing exhibit, I would ask the court to sign an order reflecting that.
Okay. Well, the court has heard the testimony in this matter, and pursuant to the applicable Revocation of Paternity Act at MCL 722.1431 at SEC, the court does believe that the evidence does clearly and convincingly demonstrate that the child is not issue of this marriage, and in fact is a child born out of wedlock, that the plaintiff has confirmed that during the time of conception that she and the defendant were not engaged in sexual relations, but in contrast, she and Mr. Wellington were. They both acknowledged that Mr. Wellington has a parent-child relationship with Joseph and have since the date of birth up until the present day. And as a result, the court does believe it's appropriate to determine that the child was a child born out of wedlock and not issue of the parties in this case, and that in fact the defendant Trevor Harley II is not the biological parent of Joseph. And as a result, once the genetic test results are filed in this case, then the court would be prepared to enter an order to that effect. So with that, Ms. Harley, is there anything else that you have?
I do have a question. So I filed this previously last year when Trevor and I had filed for divorce.
Okay.
I filed for revocation of paternity. And the original copy of the DDC report got filed with that filing. And however, I now have a copy of the original. Will that be okay?
Yes, that'll be all right.
Okay. Okay.
Mr. Magnuson, anything else?
No, Your Honor. Thank you.
Okay. Mr. Wellington, anything else from you?
No.
Okay. Thank you. And thank you all for appearing. We'll let you go. And you have a wonderful afternoon.
Thank you.
Thank you.
This matter is before the court on the plaintiff's petition to revoke paternity. We don't have the defendant obviously present.
Not.
Have you had any communication with the defendant, Ms. McNiff?
I have not, Your Honor. We've had difficulties getting responses from her. Even she didn't file a response to our complaint. She hasn't been attending hearings. I think that we had the motion asking for the DNA testing, and she didn't appear at that, you may recall.
Okay. Do you think, Ms. McNiff, that you scared her away or anything of that nature?
I could have. It's possible. Wouldn't be the first time.
Yeah, I'm sure it won't be the last. Ms. McNiff, do you wish to make an opening statement or simply proceed to take some testimony?
I would just proceed to testimony, Your Honor.
Okay, go ahead, Ms. McNiff.
Thank you, Your Honor. You are Benjamin Seifert?
Yes.
And do you know Brittany Seifert?
I used to be married to her.
Okay. And when did you divorce from her?
The divorce was finalized it was April 6, 2022.
And when you filed that divorce, were you aware of, or what, do you know whether she was pregnant at that time?
No.
Okay. And later, did you discover that she was pregnant?
Yes.
And do you know when she had a child?
April 1st, 2022.
And approximately 9-10 months prior to the birth of that child, had you had any physical contact with Miss Seifert?
Not at all. No physical contact since 2015.
Is that the last time that you saw her in person, or the last time you had sexual contact with her?
I believe both.
And is there any question in your mind that the child that she bore on and gave birth to on April 1st of 22 is not your child?
No question, not my child.
And do you know that child's name?
Yeah, Isaiah.
And do you know who Ms. Seifert is involved with romantically at this time?
Not right now, no.
Do you know who she was involved with at the time that Isaiah was born?
Yeah, his name's Delshawn Embry.
And Mr. Embry has the same last name as the child that she gave birth to in April of 22?
Yes.
I have no further questions, Your Honor.
Okay, thank you. Anything else, Ms. McNiff?
No, Your Honor, we would just ask that this court exclude Mr. Seifert as potentially being a father of this child, since he hasn't had any contact with Ms. Seifert since 2015, and the child was born 2 years ago.
Okay. Well, the court has heard the testimony in this matter as well as reviewed the file in preparation for this proceeding. The court will note that the matter is before the court pursuant to Michigan File Law 722.1441. In this case, the court will note that the testimony has shown that the plaintiff did not have any contact or sexual relations with the defendant since 2015. The divorce occurred on April 6, 2022, And as the testimony was shown that the minor child was born on April 1, 2022. And as a result, having had no contact in approximately 7 years, that he could not possibly, and it would be impossible for him to be the biological parent of the child. And as a result, the court will grant the, I should say the petition in this matter and determine that the child is in fact a child born out of wedlock, not issue of this marriage, and that the plaintiff is not the biological parent of the minor child. With that, Ms. McNiff, do you have an order prepared or?
I do not, but I will submit one under a 7-day order.
Okay, thank you. If you would do that, that will conclude the case, and best of luck to you, sir. I hope everything works out for you. You're free to go. Have a wonderful day.
Thank you, Your Honor.
Okay, very good.